Hi, I'm Emily, founder of Apex Law School Prep and Support. Just wanted to take a few minutes to go over with you today California Bar Exam, July 2022, question 4. I've heard that this went through a lot of people through a loop. It was a little overwhelming, a little confusing, so thought we could take some time, go over this, figure out how to break it down and make it doable. Okay, so as with any essay, for this one, we're going to start with the cause of the question. See that there's 4 of them. Anytime you see that there are 4 questions, you know that this is going to be a bit of a racehorse essay. You're going to need to be really efficient. Now, keep in mind, there's 4 questions. This does not mean that you are allocating your time evenly between all 4 or that you need to write an equal amount for all 4. It is very often not the case, but it does mean you need to be efficient. Okay, so let's jump into these questions. Why do we start with these? A couple reasons. One, starting with the call of the question, hopefully is going to tell us what subject or subjects are being tested on this essay. 2, it's going to tell us what facts and characters to pay attention to when we're reading the hypo. And 3, it's going to get our wheels turning on what issues they're testing, because a lot of times when you read these questions, you can make some pretty good predictions about what issues are going to come up. Okay, so let's jump into them. The first call is the agreement between Aaliyah and Bowen valid? This is not a very useful call for me at this time. Agreement. I don't know. Is this a contracts essay? Can't tell. So just going to leave it at that, knowing that I want to pay attention for an agreement and for these characters, Aaliyah and Bowen. Number 2, is Daya bound by Aaliyah and Bowen's voting agreement with respect to the election of successor directors? Okay, this is more helpful. So voting agreement, election of directors. Hopefully voting agreement rings a bell. If it doesn't, don't panic. But a voting agreement is a written agreement between shareholders to vote a certain way. And then with respect to the election of directors. So even if I don't know what a voting agreement is, I see election of directors. Hopefully I know that shareholders elect directors in corporations. I'm now thinking this is a BizAz essay about a corporation, and I'm thinking Aaliyah and Bowen, who made a voting agreement about electing directors, they're probably shareholders. If you don't see all that at this point, don't worry about it, but you can get that from that call. Okay, and then number 3, on what theory or theories, if any, might SCAR bring an action to enjoin Corp from moving solely into manufacturing bikes, and what is likely outcome? Okay, new character SCAR, don't know who that is. An action to enjoin the corporation from moving solely into manufacturing bikes. I don't know anything about this corporation yet, but anytime I see a question about enjoining, so stopping a corporation from moving into an activity, I'm thinking ultra vires activity. So this corporation, we don't know yet if it has a general purpose statement where it can do any lawful activity, or if it has a special purpose statement where it's only authorized to do one specific activity in its articles of incorporation. But if I see someone trying to enjoin a corporation from doing an activity, I'm guessing that potentially it is a special purpose statement where they're only authorized to do one thing, and my prediction is it's not manufacturing bicycles. So that's my thought for question 3. It's probably going to be ultra-vires activities. We'll see. And then number 4, on what theory or theories, if any, might SCAR bring an action for damages against Palmer related to Corp moving solely into manufacturing bikes, and what is the likely outcome? Okay, so SCAR again, still don't know who that is. This time it's an action for damages against Palmer. Don't know who Palmer is, but this is different than 3 because that was enjoining corporation. This is damages against Palmer for this same thing, the manufacturing bikes. I know if I'm thinking ultra-vires activity, that's what my prediction is for 3. Palmer moving for Palmer related to Corp moving solely into manufacturing bikes. If Palmer caused the Corp to move solely into manufacturing bikes, I know that corporations can sue directors and officers for losses caused by ultra-vires activities, but I don't know enough facts yet to know if that's really where they're going, but that would be, one guess. Okay, so those are our calls of the question. Now we're ready to jump into our facts. This is a long fact pattern. They're usually less than a page, so you might be a little overwhelmed. Just take a deep breath. You're going to take baby steps. You're going to go one sentence at a time, knowing that almost always every fact is there for a reason. Every fact has a home in your answer, right? It has somewhere you can put it that will get you points. Long fact patterns can feel overwhelming, but they can also be a good thing because the more facts they give you, the more you can IRAC, right? The more you can apply your rules to the facts in that application, you get more points for that. Also, those facts can help you remember rules if you forget them. They can trigger your memory if you left out an element or whatnot. They can help you spot issues that you might not have seen. And then they can also help you make up fake rules. So if you forgot a rule, you can reverse engineer one from the facts that you can then IRAC as if it's a real rule and still get some points. Okay, so let's jump in. So the articles of incorporation for Corp provide that it is a closely held Corp formed for the purpose of manufacturing TVs. So a couple things from this sentence to closely held Corp. I didn't see any issues that really jumped out at me necessarily from the calls of the question that were specific to closely held corps, but just things that I know that jump out at me as for closely held corps. One, majority shareholders of a closely held corp owe fiduciary duties to minority shareholders. That's not usually the case. Two, for closely held corps, there's no easy exit strategy. There's not some market that you can just sell your shares on. And then three, I know courts are more likely to pierce the corporate veil for closely held corps than for other corps. Didn't see anything about that in the calls of the question, but those just jumped out at me. Okay, and then for the purpose of manufacturing TVs. So that tells me we were right when we looked at question 3 and thought it was ultra-vires activities. This corporation is only authorized from that special purpose statement in its articles of incorporation to manufacture TVs, not bicycles. So I'm thinking, barring any other facts we might come across in this essay, that for question 3, ESCAR can enjoin that corporation from making bikes because they're only allowed to make TVs. And then insofar as Palmer, for question 4, had anything to do with this change, if Palmer turns out to be a director or officer, going to be liable for damages for any losses for this ultra-vires activity. Okay, corporation has been highly profitable in this business for 20 years. I don't know what to do with that fact yet, except I'm thinking if what they were doing, manufacturing TVs, was working for them, maybe we're going to be able to use this fact to say that shifting to something else, to manufacturing bikes, maybe that wasn't a good idea, maybe it wasn't allowed. We'll see. Okay, the articles also provide that for the purpose of electing directors, each shareholder shall have 1 vote per share that they own, multiplied by the number of open director positions, i.e. cumulative voting. Okay, if you didn't know that what they were describing was cumulative voting, they were pretty nice here. They went ahead and told you that's what it is. Cumulative voting is where instead of just having straight voting where you have whatever number of shares you have, you get 1 vote per share for each director share. What cumulative voting is it says you take the number of shares you have, so 1 vote per share, you multiply that by the number of open director seats, and then you can take all of those votes and put them just towards 1 director seat. So it can give you more voting power. Don't know what to do with that yet, but that's what cumulative voting is. Okay, Aaliyah and Bowen each own sufficient shares to elect through cumulative voting 1 of the 3 directors of Corp. Okay, so Aaliyah and Bowen are shareholders, just like we thought. They entered into a signed written agreement stating that they will vote to elect themselves to the board of the Corp and agree on the election of any successor board members. And if they can't agree, they will abstain from voting. Okay, so a signed written agreement, this is their voting agreement. So that must be what they're asking about in number 1 and number 2. So I know that they're allowed to make a written agreement, agreeing to vote a certain way. Maybe I don't know specifically if they're allowed to vote to elect themselves, but I don't see anything inherently wrong with that. It is a written agreement. That's all the rule I have in my head, let's say. I'm going to say, okay, that seems valid, right? Shareholders making this agreement, it's a voting agreement. And then they also agreed that once they became directors, they would select Palmer as the new president of Corp. Okay, this is a problem for me. I know that we're allowed to have a voting agreement for shareholders, but not directors. So once they become directors, they can't have this agreement in advance to select Palmer. I don't think that's valid. So when I'm thinking about question 1, is the agreement valid? I'm going to say it's valid insofar as they agreed how to vote as shareholders, but not valid insofar as they were agreeing how to vote as directors. And then the agreement stipulated that it would be binding on all subsequent owners of the shares. Okay, I don't know what to do with that yet, but I know that they asked me in question 2, is DIA bound? So maybe DIA is going to be a subsequent owner of the shares. I know that when I see subsequent owner of shares, I'm thinking about our transfer restrictions. Hopefully I know this. If I don't panic. But our transfer restrictions say that if you're transferring shares that have restrictions on them, like this voting agreement, that restriction is only going to bind subsequent owners of the shares if either it is conspicuously stated on the stock certificate or that new owner has actual notice of that restriction. So Aaliyah and Bowen stamped subject to agreement on the backs of all their share certificates. They stamped it on the back. I'm thinking, does that count as conspicuous? I don't think so. There's a reason they said on the back. I want to pay attention for that detail. I'm thinking that doesn't count. If I didn't know the rule for transfer restrictions needing to either be conspicuous or for that subsequent owner to have actual knowledge, I'm going to make one up using this fact. I'm going to be like, why are they taking the time to tell me that it was stamped on the back? and I'm going to make up some fake rule that maybe says it needs to be stamped on the front. Or maybe I really don't know. I'm just going to make up a rule that says like as long as it's anywhere on the stock. Whatever fake rule I make up, I'm going to apply it as if it's the real rule, and then I will still get points for showing that I know how to IRAC. But hopefully, I'm going to look at the on the back and I'm going to think like, that doesn't seem that it would really be, obvious enough to put a subsequent owner on notice. And so I'm going to make up a rule that says it has to be obvious, conspicuous, and this doesn't cut it. Okay, so that's what I'm thinking when I see is DIA bound. Again, we don't really know who DIA is, but that would be my best guess at this point. And I would think that subject to agreement on the back does not count as conspicuous. Okay. Aaliyah and Bowen were subsequently elected to Corp's board of directors, along with Chantal. Okay, so Chantal is a new character. Don't really know how to use that fact at this point, but it could just be there to sort of move the story along. But okay, so we have Aaliyah, Bowen, and Chantal. And then at the next board meeting, Aaliyah and Bowen voted to select Palmer as the new president. Chantal abstained and Palmer was named as president. Okay, so the questions didn't specifically ask me about Aaliyah and Bowen's actions, but I see here they're voting to select Palmer. I know that that's not okay. That's pursuant to their voting agreement, but I wasn't really asked about that, so I'm not going to do anything with it at this point. But now I know Palmer is our president. So when I think Palmer's the president, that's an officer. If I'm thinking about that fourth question where Esgar, whoever that is going to sue Palmer, this officer, for damages for the corporation moving to bicycles. Still don't know exactly what to do with that, but I'm thinking, okay, he's probably, as an officer, going to be liable for the losses caused by this ultra-vires activity. And I'm thinking as president, he also owes fiduciary duties to the corporation. Okay, Palmer immediately instituted several costly changes intended to shift Corp solely into the manufacturing of bicycles. Okay, so there we go. That's him causing the corporation to do this ultra-vires activity, costly changes. So we know directors and officers are liable for losses to the corporation from the ultra-vires activity, costly changes. There's our damages. Palmer reasoned that by the time the directors heard anything about the changes, Corp would be so profitable that no one would complain. So a couple issues jump out at me when I see that. So as I said, Palmer president makes me think, okay, he's an officer, he owes fiduciary duties. So loyalty, care, and disclosure. Loyalty and care are the big ones, but there's also your duty to disclose any information that could affect or harm the corporation. So when I'm looking at this, I see that he's reasoned that by the time the directors heard anything about the changes, so he's not telling the directors about this change. So that right there tells me breach of duty of disclosure, because shifting the corporation into something that they're not allowed to do could affect or harm the corporation. And then I think other duties, I think duty of care. So you have a duty of care to act as an RPP would in managing their own business. So I look here, and first of all, would an RPP managing their own business shift the business into doing something they are not legally authorized to do? No. So that tells me breach of duty of care. I always think with duty of care, defense of business judgment rule. They always go together. The business judgment rule says we will presume, give you the benefit of the doubt, presume that you're acting in good faith and in the best interest of the corporation, which means that you're not going to be liable for ordinary negligence in your decision making, but you are on the hook for grossly negligent decisions and for recklessness. And so here I'm looking at the facts and I'm thinking, okay, he reasoned that by the time the directors heard, Corp would be so profitable no one would complain. So did he believe in good faith that this was in the best interest of the corporation? Well, he thought that corporation was going to be really, really profitable from this. So that's a fact I'm going to use to say, okay, maybe business judgment rule should apply. But then this one about by the time the directors heard about the changes, it seems like he's hiding this from the directors. That tells me maybe he didn't really think this was in the best interest of the corporation. And then I think back to that fact that we had at the beginning about how the corporation had been highly profitable for manufacturing TVs. I'm going to put that in there somewhere about, was it reasonable to believe that shifting away from this highly profitable thing would be in the corporation's best interest? I don't know, if it ain't broken, don't fix it kind of mentality. So that's what I'm going to be thinking about when I think about business judgment rule. And then I'm also thinking about if he's shifting the corporation into an ultra-vires activity, That's a fundamental change, right? How do we shift? How do we change what the corporation is authorized to do? We need to make an amendment to the Articles of Incorporation. That's a fundamental change. That requires directors to vote. That requires shareholders to vote. That is beyond the scope of an officer who can only do day-to-day management decisions. So that also is going to be exceeding his role. I'm going to say that is a breach of duty of care as well. And I'm going to say that, yeah, he thought this would be profitable, but it wasn't reasonable. And the fact that he was hiding it suggests that maybe it wasn't really in good faith. I'm going to say business judgment rule is not going to apply here. So that defense is a loser, and he's going to be liable for breaching his duty of care in addition to that duty of disclosure. So that's all the stuff I'm thinking about with that paragraph. And then I'm looking at the next one, thinking, okay, Bowen discovered almost immediately what Palmer had done. Okay, I don't quite know what to do with that, so I'm just going to leave that alone for now. Bowen then informed Daya of all of these facts, sold his shares to her, and resigned from the board. Okay, so Bowen is telling Daya these facts and selling his shares to her. So now that confirms Daya is the subsequent owner of these shares. So think about question 2. Is Daya bound by the voting agreement? So that is that transfer restriction thing that we talked about. So only if it was conspicuous or Daya was on notice. We said the back of the certificate, probably not conspicuous. Was Daya on notice? These facts seem a little vague to me. Bowen then informed Daya of all of these facts. Does that include the fact of the voting agreement restriction? If it does, then I'm going to say, okay, well, even though it wasn't conspicuous, Daya had actual notice, so yes, Daya is bound. If all of these facts doesn't include the voting agreement restriction, then no, Daya is not bound. And I'm just going to IRAC both of those in the alternative. I'm going to tell the grader about these assumptions. I'm going to say if all of these facts includes voting agreement, then yes, actual knowledge and bound. If not, then no, actual notice and not bound. I'm going to do those in the alternative, just being really explicit with the grader about how I'm interpreting the facts. And then, so informed Daya of the facts, sold the shares, and resigned. Okay, don't know what to do with that yet, so just going to leave that there. Escar, a shareholder of Corp since its inception. Okay, now we know who Escar is. Escar is a shareholder, wishes to seek legal relief regarding Palmer's actions and Corp's change. Okay, so Escar is a shareholder, and 3 and 4 are about Escar bringing suit. Hopefully I know that shareholders can bring direct suits for their own injuries, and then when they win, whatever recovery they get goes into their own personal bank account. Or they can bring derivative suits asserting the corporation's injury on the corporation's behalf, and when they win, that recovery goes into the corporation's bank account. So thinking, okay, when Escar's bringing these suits, it's either going to be direct or derivative suit. And I see he's been a shareholder of the corp since its inception. Hopefully what that triggers for me when I'm trying to always read these facts, thinking like, how can I use this? Why is it there? If we're talking about a derivative suit, there's 3 requirements for a shareholder to bring a derivative suit. One is contemporaneous ownership. You have to have owned at least 1 share of the corporation at the time the injury occurred and through the whole lawsuit. So he's been a shareholder since its inception. That tells me that he's had at least 1 share since the time the injury occurred. So that element's going to be satisfied. And then he wishes to seek relief. Okay, so I'm thinking those second and third requirements for derivative. So is he going to adequately represent the interests of the corp? No reason to think he won't. There's no facts here to suggest otherwise. And then 3, that third requirement for a derivative suit is he has to make a demand on the board or show demand futility. So making a demand on the board is going to the board and demanding that the board cause the corporation to bring the action itself. Right? Hey, corporation's been harmed. You're the mouthpiece of the corporation. Cause the corporation to sue to protect itself. If the board says no, then you can go ahead and bring that derivative action. If they do nothing and 90 days pass, you can go ahead and bring that action. Or instead of making that demand, you can show demand futility if you can show that the board was tainted, meaning they would never vote yes. And so what was the point? It was futile to even go to them and ask and make this demand. So you can just skip that step if you show demand futility and then just go straight to filing your suit. So when I'm thinking about whether demand futility would apply here, I'm thinking, okay, so who's the board? It's Aaliyah and Bowen and Chantal. I'm thinking Escar is going to go to them and ask them to sue Palmer. Palmer is Bowen and Aaliyah's horse. So can I make an argument here that making a demand would be futile because Bowen and Aaliyah are tainted and they're never going to vote to have the corporation sue the person that they selected? I'm going to try to make that argument, but then I'm also keeping in mind this fact that I didn't have a home for until now. that he resigned. Bowen resigned from the board. So Bowen, that tainted director, is not there anymore. So perhaps demand is not futile. But that gives me a way to use that fact. Okay, so that's all of the facts. Let's just run through making sure we're answering the calls of the question and see if there's anything else we can use here. So is the agreement between Aaliyah and Bowen valid? We're going to say it's that voting agreement. It's written. Shareholders are allowed to do it. That piece is valid. Directors are not allowed to do it. So the part talking about them agreeing to select Palmer, not valid. Is Daya bound by the voting agreement? So that's okay, only if it's conspicuous or if she has notice, not conspicuous because it's on the back, and then notice, maybe depending on what all of these facts that Bowen told her about includes. And if you don't know, if you can't decide if on the back counts as conspicuous or not, it doesn't really matter how you conclude as long as you're showing the grader. Hopefully you know the rule or you made a fake one up, but it has to be conspicuous, whatever your fake rules, and then you apply it in some sort of internally consistent, logical way. So if you can say, well, on the back is consistent because, if you can come up with a way to justify that, it's not going to hurt you if you conclude that it's not conspicuous and it really is, or vice versa, right? As long as you are IRACing it and using the facts. Okay, so that's that one. And then 3, on what theory or theories, if any, might SCAR bring an action to enjoin corp? So that's the ultra vires activities. Yeah, he's going to win this, right? Because the corporation was not allowed to do this because of the special purpose statement that said just TVs. And then on what theory or theories, if any, might SCAR bring an action for damages against Palmer related to moving into bikes? So we talked already, you want to talk about a derivative suit here, first of all. And so it's going to be for those losses caused by the ultra vires activities and for that breach of fiduciary duties. So those breaches are going to be disclosure and duty of care. The business judgment rule is going to be a loser argument here. And then again, you can say if you can throw in there that the proper thing for Palmer to do would have been, instead of him doing this himself, the corporation really needed to pose to the directors and then to the shareholders this fundamental corporate change to amend their articles of incorporation. And then any damages, if SCAR wins, it's a derivative suit, so those damages will go to the corporation. So that's where we land on this essay. There's probably some more little issues in there, but that should be plenty good on points to get you passing with a nice cushion. You may run out of time because there's so much to talk about here. Don't stress out. If you run out of time, you can absolutely still pass as long as you are being efficient and doing a good job IRACing the stuff that you do have time to write about. Okay, so hopefully that was helpful for you. If you found that helpful and you want some tutoring, if you want to sign up for a bar prep course, you come to our website, apexlawprep.com, with outlines, approaches, all sorts of materials for you. Okay, best of luck.